Welcome back, my friends. We are on the home straight now. We're going to stop talking about the money and we're going to start talking about the duties that lawyers have to other practitioners. So as you're already aware, there's high expectations when it comes to the standard of professional conduct that lawyers are expected to commit to. And that's not just confined to the relationships that they have with their clients, which we've been spending a lot of time talking about, or even with the court, which is the highest duty of all and where we will go to shortly. When it comes to dealing professionally with other lawyers and with people other than clients, lawyers' conduct needs to be characterised with principles of good faith, honesty and fairness, and all of these things are required with their relationship with clients and the court, so high expectations with each other and with the community at large too. So lawyers can assume legal duties to third parties as well as professional duties to other lawyers and to non-clients in certain circumstances. And that's really what I want to talk about in this video. It's important that you think about the difference between legal duties, so enforceable duties, and professional duties as we work through the following parts of the lecture. And this is a distinction actually you should be thinking about in the context of all the different relationships that we're exploring. So in this context, the difference is usually about the differences between duties capable of generating a personal civil liability to a third party and those that will be sanctioned chiefly via the disciplinary process. So some of them are about enforceable obligations that the lawyer takes on. So that is the legal duty. And the professional duties, when they are breached, that's a situation where they may experience some form of disciplinary process. So in dealings between each other, lawyers need to act with honesty, fairness and courtesy, and they need to adhere to undertakings so as to lawfully and competently transact the work that they perform for clients in a manner that is consistent with the interests of the public. So the idea behind this is that there will be confidence, mutual respect and cooperation between lawyers, which in turn will promote the efficient administration of justice, which will serve the client and the legal process, as well as being instrumental in fostering the reputation of the profession. It's really important to note that offensive and disparaging comments to other lawyers about other lawyers it's just simply unprofessional. When performing your duties and your obligations, you need to be honest and accurate in your representations. This means you need to be professional and courteous in all communications. You mustn't use insulting, provocative, nasty language. You can't be acrimonious or offensive in your correspondence. And ultimately, this is unbecoming, discourteous, and actually could result in professional sanctions. It cannot be said without qualification that lawyers must always refrain from communications which could otherwise be justified in their tone and language merely because the recipient might find them discourteous, provocative, or even offensive. Even so, there is a balance here. You can't not say something that is true or that furthers your client's interest, even if pointing out to the other side that their interpretation of the law is incorrect or that they've included an unenforceable provision in a contract. But you need to find a way to do it that is professional. Communications from lawyers need to be frank. They need to be clear and they shouldn't be confusing. The intended audience of communications will always determine the form, nature, and complexity. And the way that we write to other lawyers might be quite different from the way that we write to our clients. Even so, we maintain professionalism. There are little quirks that you see from time to time, and the one that makes me laugh, and you'll see it in judgments quite often, particularly when an appeal is overturning a prior instance decision, with the greatest respect. which effectively means you're wrong. And with respect means you're wrong. With the greatest respect means you're really stupid and wrong. No, that's just my interpretation. So keep these things in mind. Chapter 22 of Dal Pont. Make sure you work your way through it. It can be a little bit overwhelming at first. There's a lot in there, but it is really important that you understand the importance of undertakings and the issues that have come up for lawyers when it comes to interpreting undertakings. The conflict here tends to be in the cases if a lawyer gives an undertaking, in other words, makes a promise to somebody, is that promise given on behalf of their client, or is it a professional undertaking that has been given by them personally to the lawyer on the other side and intended to be relied on by the lawyer on the other side or their client? So Dal Pont notes that there's no special branch of the law to deal with solicitors' undertakings, and the question of whether a solicitor will be liable on them will be part of the general law of contract, subject to the special difficulties of interpreting the undertakings, special difficulties because of the nature of the solicitor-client relationship and solicitor-solicitor relationships, or lawyer-lawyer relationships. And again, we keep coming back to this, the potential for an information asymmetry and the nature of the reasons for giving undertakings, which usually, when given to another law firm, are about expediting and moving things forward. So the question of whether a solicitor will be liable on an undertaking is ultimately a question of contract. A lawyer who has no intention of undertaking personal liability needs to make it very clear that the undertaking is given on behalf of the client and for the client only. So we're thinking about that then as a matter of agency. A court will look really closely at the terms of an undertaking that is given to ascertain, to work out whether the lawyer who has given it on their own behalf or on behalf of the client. So undertakings are regularly given to other lawyers, but they also might be given to another third party, hence kind of putting them into this spot. The words that are used in the undertaking will be construed both in their context and taking into account objectively how those words would have reasonably have been understood by the person who heard them, received them, they're usually given in writing, in the circumstances. A statement in an undertaking that the undertaking is being given as a solicitor and agent for a client and not in a personal capacity, or to the effect that it is the client who gives the undertaking, will ordinarily be indicative of a disclaimer of personal liability by the solicitor or by the lawyer giving that undertaking. But if there is any ambiguity at all, it will usually be construed strictly against the lawyer giving the undertaking. In Russo and Dupree, a solicitor had undertaken to protect the costs and disbursements of another lawyer from whom the solicitor had taken over the conduct of a personal injuries claim. So this is the kind of circumstances that we're talking about not that long ago. Well, I wasn't talking about them that long ago. I don't know what the gap is between you listening to me and... but anyway, let's not get distracted. So this is a situation where the client has changed lawyers midstream and the new lawyer is giving an undertaking essentially so that the old lawyer won't exercise a lien over their file. And so that gives the new lawyer access to all of the materials that they need. It was actually a personal injuries claim, not sure that really matters. But so Justice Bryson construed the undertaking as being given by the solicitor itself based on the words that were given. So it was seen as being a personal undertaking, but at the same time, Justice Bryson was unwilling to impose on the solicitor any kind of personal obligation that come what may, the costs would be paid out of the solicitor's own pocket if necessary. So the undertaking, even though it bound the solicitor personally, basically required that lawyer only to take reasonable steps to protect the other lawyer's costs and disbursements. There was no personal guarantee or promise that they would be paid. So it follows that the rule of construction will give way to any contrary expression or implied intention of the parties. The position is clearer again when you're looking at personal undertakings that are given, personal undertakings against a lawyer that are inconsistent with the nature of the legal relationship that the parties intended to create. So Dal Pont uses Barclays Bank and Weeks, Legg and Dean to illustrate this point. The solicitors acting for the purchases of some land gave the bank, which had advanced the purchase monies on the security of certain properties, an undertaking that the sums that had been received would be applied only for the purpose of acquiring a good marketable title to the property itself. The bank ultimately sued the solicitors for breach of the undertaking, claiming that the solicitors had failed to obtain a good title that gave the bank sufficient security. So the issue here was whether the solicitors had given an absolute undertaking, so assumed personal liability if they parted with the monies without obtaining good marketable title, even without their own default, or only a qualified undertaking, in other words, an undertaking of liability only if the failure was due to some default or issue that they created themselves. Ultimately, the English Court of Appeal saw either interpretation as open on the wording of the undertaking, so it could be read either way, but the following reasons led it to conclude that the parties had meant it to be qualified. Firstly, the parties were unlikely to have intended the solicitors to assume a duty to the bank. It was not their client, the bank wasn't paying anything for their services. So it was weird is completely the wrong word. It was really difficult to see that the parties would have intended that the solicitors have a greater liability than the duty that they had to the bank than the duty that they'd assumed towards their own client. Secondly, the undertaking related to the investigation of the vendor's title as well as to the vendor's execution of the conveyancing documents. But it was impossible for a purchase solicitor to give an unqualified guarantee of the vendor's title. Thirdly, it's really hard to glean what steps a purchaser's solicitor could have taken to ensure that the conveyancing was properly executed by the vendor. And lastly, number 4, the purpose of the undertaking was to set the terms on which the solicitors were authorised to part with the money that belonged to the bank. So it was difficult to see why they should assume an even more onerous obligation in contract than they would assume in equity. So ultimately, this undertaking was construed in such a way, and here construed means understood by the court. It aligned with the idea that the solicitors' obligations under it were aligned with their obligations to their own client and with the client's obligations in equity to the bank. And so they weren't personally liable for the undertaking that had been given. So as a general rule, it's fair to say that an undertaking that a lawyer gives when they are a party to a legal matter will be an undertaking given in their profession. So the use of the word undertaking here isn't essential for an undertaking to be given. As Dal Pont puts it, the jurisdiction, in other words, the attention of the court and the enforceability of the undertaking can be attracted or is available whenever a solicitor or a lawyer has accepted an obligation in their capacity as a lawyer. But it's important that the court looks really carefully at the scope of the undertaking and whether or not it's personal, will really depend on the language that's used, just as it would when you're looking at whether somebody has liability in contract generally. So have a look at Dal Pont, chapter 22, paragraph 20. So far as the requirement that an undertaking be given in a lawyer's professional capacity is concerned, the phrase "in their or capacity as a solicitor" has been held to go as far as when a solicitor, in the course of business which they are conducting for clients with third parties in the way of their profession, gives an undertaking to those third parties incidental to those negotiations, that undertaking will be one that will be given in their capacity as a solicitor and not as a mere layman undertaking the office of a stakeholder or guaranteeing the payment in money. So in other words, I'm reading from the text, which is very unhelpful. I'm sorry about that. But in other words, because you are a lawyer, when you give an undertaking to another lawyer or to a third party who knows that you are a lawyer, that will be held at the higher standard unless you are very clear that you are not making that promise in your personal capacity. So ultimately, it's really important to be really clear about whether you are giving undertakings on your own behalf or on behalf of a client, or whether promises that you make are intended to be contractually binding or attract the level that is required for them to attract disciplinary consequences if you fail to meet them. In other words, is it a professional undertaking, or is it just a promise that you make as a business person trying to do a deal? Being really clear is absolutely important here. So have a look at Dal Pont on these points. I don't want to belabor them, but this is something that from an exam point of view, it's not at all unusual to see questions involving undertakings. So it's a good thing to keep your eye out for. The last thing that I want to mention when it comes to our duties to other practitioners is what's referred to as the no contact rules. So at its simplest, the no contract law, or no contract rule, provides that a lawyer must not communicate with somebody they know to be represented by another lawyer in a matter without that the representing lawyer's consent. This rule applies to both oral and written communications, as well as to attempts to contact an opponent via social media sites, so LinkedIn or Twitter or something like that. Although ultimately this doesn't preclude lawyers from passively reviewing publicly available content of those sites. So actually contacting is quite different from looking at what is publicly available. The no contact rule aims to prevent lawyers from circumventing the protections that legal representation provides to persons who require legal representation. Most commonly, it's the opponent, but it extends to represented co-parties or non-party fact witnesses, as well as non-clients who might be represented prior to any suit being filed. The no contract rule extends to employees or to agents of the lawyer as well. And a breach of the rule, though chiefly viewed as a professional issue, can generate legal consequences as well. They can include the court ruling inadmissible, any evidence that's gathered as a result, or ordering the return of documents and notes, even ordering a lawyer to be disqualified in the proceedings. So it's something to be really careful about. It's something that we had to caution lawyers about early in the life of LinkedIn. Young people in particular, often are very keen to build up their networks, and so immediately after the first roundtable conference on negotiating a deal, you'll find ping, 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 a little tsunami of LinkedIn requests, and often you'll find that the people on the other side will seek to connect with you on LinkedIn or in some other like social media context. And it's really important to make sure that you don't accept those requests, and you certainly can't send out requests to people who you've met in that context. So in the next video, I'm going to move on and talk more generally about duties to third parties. I do want to be clear. I kept undertakings in this section with duties to other practitioners because that's where I see it play out most commonly. But everything that I said there relates also to third parties as well. So I'll see you in the next video. Cheers.